Sports governance. Sports awareness. Sports accessibility. Sports facilities development. Sports linkages. Institutionalization of the Philippine Sports Institute. Legislative initiatives and interagency collaborations. Bahagi na ng buhay nating mga Pilipino ang sports. Mula sa panahon ng unos, sa tamis ng tagumpay, sa kabila ng pagbabago ng buhay, ang Philippine Sports Commission ay patuloy na magigilingkod sa sambayanan at atletang Pilipino.
Hi everyone. On behalf of the Sports Arbitration Committee of the Philippine Dispute Resolution Center Incorporated, I would like to thank the Philippine Sports Commission for inviting us to be part of Make It Sports project. We are honored to be sharing with you some important information about alternative dispute resolution and sports arbitration in particular. I am Attorney Charlie Ho, a lawyer and arbitrator. I chair the PDRCI Sports Arbitration Committee. I'm also a doctor of optometry who specializes in sports vision. The title of my presentation today is Sports Arbitration, an essential cornerstone in national sports development. Conflicts in sports is common because people differ in their views, values, needs, and culture. Everywhere you go, organization, workplace, conflict is a part of life. Conflict is not a problem if it is handled properly. If conflict in organizations are mishandled, it can lead to power struggles, faction fighting, thus affecting the management of organizations and, more importantly, the performance of the athletes. Sports leaders and officials managing sports organizations should prepare to deal and manage conflicts. Ideally, every organization must have a grievance mechanism, and the mode of conflict resolution should already be established. But what if there is no mechanism in place? The aggrieved party often have no recourse but to go to the regular courts to seek redress of their problem. Now, this is what the sports community wants to avoid. That is, bringing sports disputes to the courts. Generally, if it can be avoided, sports people would rather settle among themselves. So the concept of sportsmanship is such that we are bound to accept defeat and magnanimous in victory. That's the essence of sportsmanship. Pero marami sa atin kapag natatalo, hindi matanggap yung pagkatalo. So they would drag other people down with them. And this is what is pulling Philippine sports downward. Ultimately, the athletes are affected by the leadership conflicts. Unresolved conflicts deter sports development because athletes are demoralized. That some either quit the sport, change citizenship, go overseas, or retire too early. That's why we don't see the best representations in international competitions. How many sports stakeholders bring their dispute to the regular courts? How many contracts of athletes and coaches are one-sided? How many were not selected because of favoritism or politics? Many of these issues were not resolved because there was no mechanism to speedily and justly resolve the disputes. Sports arbitration is the preferred mode because it mimics court function. The arbitrators render an award and the judge render a judgment. In sports arbitration, the arbitrator understands sports and sports law, while the judge maybe not. Arbitration has about 1 to 3 arbitrators as against just one judge in regular courts. So an arbitration case is studied carefully and a case is quickly resolved as against a court case, which may reach 3, 5, or even 7 years. To distinguish arbitration from mediation, arbitration is the more often used form of ADR to resolve conflict in sports. You might have already noticed. You witness this in international alternative dispute resolution. The International Olympic Committee, International Sports Federation in football, basketball, and other sports. In cases related to anti-doping or use of performance enhancement drugs, the sports organization required sports arbitration as the mode of ADR because they want sports out of the hands of the courts and they want a speedy and inexpensive resolution to issues hounding sports. Also because sports arbitration cases are heard by trained specialists in anti-doping. Arbitration involves submission of a dispute to a neutral decision maker, that is the arbitrator. For what? For a final resolution of a disagreement. So it is characterized by binding or non-binding or either mandatory or voluntary, which means that the decision of the arbitrator cannot be challenged in court. Sports mediation, on the other hand, is a non-binding and informal procedure based on a mediation agreement in which one party negotiates with the other party with the assistance of a mediator with a view to settle a sports-related dispute. Mediator will only assist the parties. arrive at a settlement. So it's not the mediator that is deciding the case, unlike in arbitration. So why should we choose sports arbitration over mediation? For obvious reason or reasons that we have already discussed. Sports arbitration is preferred in many countries because there is a final resolution. It is fast and inexpensive. Why? Because there is a time frame within which they should come up with the resolution. And what is unique here is that the arbitrators are mostly specialists in sports and in sports law. There is finality because it cannot be challenged before the courts, except if there is fraud or there is absence of due process. It is fast because there is a time frame to resolve a conflict. With PDRCI, for example, disputes may be settled between 30 to 90 days, depending on the nature of the dispute and agreement of the parties. So there can be interim measures of protection issued by the arbitral tribunal to protect the interests of a party. The arbitral tribunal is what we usually call the panel of arbitrators. Similar to a TRO or a temporary restraining order, the arbitral tribunal can issue that in order to protect the interests of the athlete or the coach or the complainant or what we call the claimant. So this is unique and this is attractive because in sports arbitration, it's not always about fighting over money. Sometimes it's about eligibility and selection issues. And in these two issues, the timeliness of decisions is of the essence. Mediation may be chosen by the claimant or the complainant if you do not want to burn bridges with the respondent. So if you want to preserve relationships, then mediation is the mode for you. Mediation is appropriate only if you are not in a hurry. And I would suggest. Why? Because there is some parts or the process in mediation where delay is happening, such as negotiation or the drafting of settlement agreements, which usually take time. And if you don't have parties who are not, who are cooperative, then it will sometimes take more time to arrive at a final settlement agreement. In selection and eligibility issues, again, you want a third-party neutral to come in and decide who is right and who is wrong. So we can all move on quickly because competition is next week. And you need to travel and you need to forward the names of the league organizers. So kailangan mabilis talaga. Basically, if you want to preserve relationships, again, mediation and not arbitration is the right move. In arbitration, there are two types. One, mandatory, and the other is voluntary. In mandatory, if a sports contract, for example, contains an arbitration clause, or the rules and regulation or the constitution and bylaws of the organization provides for arbitration to settle disputes, then you have no choice. You are not allowed to go to court. The arbitration clause contains the manner or procedure to be followed, the procedural rules to be used, language, the number of arbitrators, the seat of arbitration, the place where the hearing is going to take place. It's voluntary when there is no contract involved or there's no contract to speak of, therefore providing for an ADR mechanism. But despite the absence of that contract or rule, the parties may still agree to submit their dispute to arbitration via what we call a submission agreement. So the conflict or the conflicting parties will sign the contract that they agree to submit to arbitration. And that would make the courts, or that would exclude the courts from the process. So we also have to know if the arbitration is domestic or international. So when is an arbitration international? It depends on what the arbitration clause in a contract says, or what the constitution and bylaws of the organization where he is a member says. So we also look at the contracting parties. When one of the parties is foreign, or it has been agreed that the seat of arbitration is outside the Philippines. So when you say the seat of arbitration, we are referring to the law that applies to the procedure and to the tribunal. It's domestic if arbitration is not international. That is how simple the definition of domestic arbitration is. Local laws apply and the parties are local. So let's look at some terminologies. Conflict and dispute are synonymous. So what is a dispute? It's a conflict or controversy. While dispute resolution refers to the process used to resolve the conflict. And a sports-related dispute is one that involves matters of principle relating to, or matters of pecuniary, meaning money claims, or other interests brought into play in the practice or development of sport, or any activity related or connected to sport. So let's look at how sports disputes are currently resolved. First, if a decision was made within a sports association and this decision triggers a dispute, an appeal to that internal authority created by the sports association concerned is likely. If it involved the rules of an international sports federation, then we follow the process that is stated in their rules. If there are no mechanisms in place, or there is no such ADR available, then the agreed party may bring the case to court. Of course, that is the consequence of not having an ADR. Third, the disputes are submitted to arbitration or mediation. So this is often practiced in developed countries. In sports arbitration, the most popular international ADR provider is the Court of Arbitration for Sport, or CAS. So I'm sure you have heard about CAS, and this is connected to the International Olympic Committee because it was a creation of the IOC, but now it is independent. So the disputes handled by CAS originally are related to the Olympic Games and the violation of the World Anti-Doping Code. In the study of sports law and international ADR, we cannot help but look at CAS because CAS is considered globally as the Supreme Court of sports. CAS is an institution independent of any sports organization, which provides arbitration or mediation to serve the specific needs of the sports world. You know, the founding purpose of CAS was to take international sports disputes out of the national courts and provide a highly specialized forum where those disputes could be heard and decided quickly and inexpensively according to a flexible procedure. So CAS, as I said earlier, CAS used to be a part of the International Olympic Committee in 1983. It became independent only in June 22 of 1994 by virtue of the Paris Agreement. So it is now the International Council of Arbitration for Sport that is running CAS. So CAS, which is based in Switzerland, follows the rules according to the Swiss Federal Code. Now, CAS has four main divisions: the Ordinary Division, Appeals Division, Anti-Doping Division, and Ad Hoc Division. So the Ordinary Division is where filing of a case is first initiated. Whereas in Appeals Division, this is where when you appeal a decision of an organization, you can file it with the Appeals Division. In Anti-Doping Division, this is where doping cases are filed exclusively as prescribed by the World Anti-Doping Code. So there are now 48 WADA member countries, Philippines included, who are signatories to the code and must comply with the World Anti-Doping Code. So what is WADC, or the World Anti-Doping Code? It is a document that harmonizes regulations regarding anti-doping in sports across all sports and all countries of the world. The code provides a framework for anti-doping policies, rules, and regulations for sports organizations and public authorities. So the ad hoc division, on the other hand, convenes only when the games are held. For example, the Olympics, the Asian Games. These are Winter Games. These are the international competitions under the International Olympic Committee. So in competition disputes, they have a time frame. The dispute must be settled within 24 hours. So in the Olympics, Asian Games, ad hoc arbitration is now available. And I think in 2019, also in the Southeast Asian Games, also applied the ad hoc arbitration policy. So let's check what are the common disputes filed with the CAS. Disputes arising from contractual relations regarding unpaid compensation, salaries or wages, player transfers, breach of contracts by clubs or players, issues of civil liability. These, by the way, fall within the jurisdiction of the CAS Ordinary Division. Disputes that are commercial in nature, which also fall under the Ordinary Division, are TV broadcast rights, marketing agreements, sponsorship contracts, licensing requirements, and the like. Disciplinary disputes that follow decisions by a sports organization fall under the Appeals Division of CAS. Violation of anti-doping rule, eligibility, selection, or nationality issues. The disciplinary cases of an international nature rule in appeal are free, except for an initial court fee or court office fee of 1,000 Swiss francs. It's about 55,000 pesos. So these are the common CAS cases. But not all sports disputes actually reach CAS because of the nature and type of disputes. Remember, CAS is a form of international ADR and often involve transnational parties. How about local sports disputes? Except for disciplinary disputes arising from doping cases, or when the dispute involves an international sporting body that is linked to the International Olympic Committee, other disputes may be settled using domestic alternative dispute resolution. So why do we need to understand CAS and international ADR? Well, when the subject matter is related to the Olympic Games or anti-doping, at least for these two instances, then you have to go to CAS exclusively. So you cannot bring it to for domestic arbitration because it will not be accepted for lack of jurisdiction. National Olympic committees like what we have here, the Philippine Olympic Committee, members of the IOC are required to comply with the IOC Charter. The National Sports Associations in the Philippines, affiliated with international sports federations who have designated private bodies like in football and basketball, they appeal to CAS. International players contract, sports events, international competitions for ad hoc. So if you are part of the Philippine delegation or you lawyer for a Philippine team, you need to know all this because of in case of game protests. If you are an international sports fan, a sports lawyer, a sports arbitrator, you need to understand this to appreciate international arbitration. However, the Philippines need to set up an effective sports ADR mechanism to resolve local sports-related disputes. Hindi naman pwede puro international or CAS lang. Paano naman yung mga local disputes? Di ba? So, we need sports arbitration applied locally so that we can help settle disputes that are purely local or too petty sometimes. So for so long, sports-related disputes have taken its toll on Philippine sports because of non-resolution of disputes. So if we badly need sports arbitration to run in the Philippines, what does it take to have one? We need an ADR institution which is accredited by the Office of the ADR, which is part of the Department of Justice. And the provider has a roster of trained and accredited sports arbitrators who specializes in arbitration, sports law, those preferably with extensive experience in the industry or has been a former athlete or coach or a sports leader or a sports official. So yung background mo sa sports may advantage. No? It will help you in evaluating and deciding cases. So a set of sports arbitration rules is also needed. You know? So the provider has to have a set of sports arbitration rules. So this is important because it promotes a speedy, inexpensive resolution of sports dispute. Dito natin makikita. No? If you look at the rules of the institution, dito natin makikita how a sports arbitration process is going to be run, no? How it is going to happen. So, then we help the institutions and the sports organizations establish the legal basis for referring their disputes to sports arbitration. So we are trying to provide the legal basis so that it somehow it becomes mandatory on the part of the parties or members of an organization so that kapag nagkaroon sila ng dispute, no, they have no choice but to bring their case or submit their case to sports arbitration. So pwede natin siyang ilagay sa contract, pwede natin siyang ilagay sa constitution and bylaws ng organization or the rules and regulations of the sport itself. So we in PDRCI can offer our expertise to both the government and the private sector, amateur and professional sports as well. So the orientation and developing of the ADR culture will take time, but it will get there eventually. So we may also offer ad hoc arbitration for sports competitions like Palarong Pambansa, Patang Pinoy, and other local sports competitions. So pwede amateur and professional leagues, for example. The ADR institution and the arbitration rules are now available and they are now in place. So we have the PDRCI, the first institution to offer sport mediation and arbitration in the country. The arbitration rules address the special needs of the sports industry. So parties may file non-monetary claims such as eligibility, selection issues. Kaya ko sinasabi yung non-monetary claims is because right now, most of the arbitration that is happening in the Philippines are commercial in nature. Kumbaga, mayroong pinag-aawayan na monetary values. Okay? So we also have intra-corporate disputes of sports associations. No? Ito yung mga infighting between the leaders of an organization. I'm sure you are very familiar with this. So we have flexible options. We have mediation, arbitration, or mediation arbitration model, or MEDAR. So we offer quick resolution to disputes, which is what sports stakeholders really need. We are a good alternative to the courts. Yun lang yung sinasabi natin. Kasi pag inakyat natin sa korte, abuti tayo ng 5 taon siguro bago ma-resolve yung case. No? So when you file a case in court, you are not sure when the case will be resolved. But in sports arbitration, you know there is finality and predictability because you know that the tribunal will have to release its decision within 30 or 90 days, no? Depending on the procedure that you opted for. Another feature is one may opt for is emergency arbitrator, or you can also go for interim measures of protection, which may be issued to protect the rights of the claimant. So kung nagmamadali ka, for example, if you're talking about selection issues and the competition is next week and the team is supposed to leave in the next 2 days, maybe you would want to go for emergency arbitrator. So they have the powers to issue interim measures of protection if warranted. So the PDRCI has a roster of trained and accredited mediators and arbitrators who are sports law experts, experienced arbitrators, arbitrator athlete, former athletes, former referees, sports managers, and sports officials. So, sino sa tingin ninyo magbe-benefit? Who will benefit from all this? So, I would say everyone. Athletes, coaches, amateur, professional leagues. You talk about eligibility, selection, disciplinary issues, violation of league rules, salary disputes. This is common in professional sports. Impasse, sit-outs, trade issues, eligibility, and then controversies arising from sports competitions in amateur and professional leagues, game protests, league rules, violation, also eligibility. Then issues with sports federations, we have leadership and intra-corporate. So hindi na kailangan dalhin pa sa CAS yung mga nag-aaway, for example, yung treasurer at yung president. So you don't need to go to international ADR for that. Dapat local na lang. So sports event, contractual disputes. So hindi lang ito about athletes and coaches. Anything that is related to sports, it can be, you can be an event organizer, you run competitions, you have sports contract, you can go for sports arbitration. The major institutions where sports arbitration will impact Philippine sports, ito yung mga major stakeholders ng Philippine sports: Philippine Sports Commission, Philippine Olympic Committee, national sports associations, collegiate, amateur sports organizations like the UAAP, NCAA. We have DepEd and PSC-run competitions like Palarong Pambansa, Batang Pinoy, and we have the Games and Amusement Board, or GAB, which regulates professional sports. So we want sports arbitration to be adopted by these institutions. So let us look at the current status of ADR mechanisms in amateur sports. So where Philippines is a participant in international competitions, being a member of the IOC and the International Sports Federation, we have no choice but to be involved in international sports arbitration. So the sector who belongs to this category are the NSAs who are members of the POC. So these NSAs are the national governing body for the sport in the country. For example, Samahang Basketball ng Pilipinas is the national governing body for basketball in the Philippines. And then football, the Philippine Football Federation. So there's only one national governing body for each sport in the Philippines. So in case of dispute, the parties can first use their internal mechanism to resolve it. If it fails, then the POC bylaws would come in. It's a bit confusing because the NSAs are members of the POC, so the NSAs are also bound by the Constitution of the Philippine Olympic Committee. So if the Philippine Olympic Committee says, if you cannot settle your dispute, you have to come to me. We will be the ones who will settle your dispute. So the POC acts as the final arbiter of the dispute. So that is as of today, because the POC is supposed to amend its bylaws. So maybe they will have a new bylaws by next year. So if the NSA does not agree with the decision, then the decision is appealed to CAS Appeals Division. So now this is provided for by their charter. So for violations of the anti-doping code, especially in international events, then the anti-doping division of CAS has exclusive jurisdiction because this is provided for by the World Anti-Doping Code. And this is also the requirement of the International Olympic Committee. Now, for other intra-corporate disputes within an NSA, meaning where there are disputes among the members of the federation, kunyari, nag-aaway-away yung treasurer and secretary, whether they are POC members or not, then there is another law, the Revised Corporation Code, or RA 11232, Section 181, that applies. So this provision of law mandates that disputes be settled by arbitration when the bylaws of the corporation so provides. So in 2019, the POC has taken a step towards that direction that seeks to use domestic arbitration to resolve disputes. However, there is a need to amend the Constitution to allow domestic arbitration because currently the bylaws of the POC does not provide, expressly provide for domestic arbitration. So for this purpose, a memorandum of agreement was signed between the PDRCI and the Philippine Olympic Committee in January 14, 2019, during the presidency of Mr. Ricky Vargas. So both institutions have agreed to work together to establish an ADR system for the Philippine Olympic Committee. Now, how about non-POC members? So non-Philippine Olympic Committee members. Can they avail of sports arbitration, or do they need an ADR mechanism? Well, certainly. So the talent-rich amateur leagues are the source of our elite athletes. This is where a student athlete's potential discovered. This is the sector that should be nurtured. And sports arbitration will be a key to stability in this stage of sport development. They can hear and decide disputes if internal mechanisms are in place. So setting up one will prevent people from going to court. Now, since PDRCI is already available, we must encourage them to adopt sports arbitration. The agency that has the most persuasive powers, I believe, is the Philippine Sports Commission. So let's look at their mandate. Under Section 11 and Section 13 of the law creating the PSC may exercise supervisory and visitorial powers only in connection with the financial assistance extended by the Commission. You know, the character of the National Sports Associations and the Philippine Olympic Committee, they are actually autonomous. No? But hindi total yung kanilang, or absolute yung kanyang autonomy. Because when it comes to issues where financial assistance that is extended by the Commission to the POC or to the NSAs, they are not really autonomous in that sense. No? Because the PSC may look into the issues using its visitorial powers. So there is nothing in the law that provides for resolving disputes or any reference to the exercise of quasi-judicial functions by PSC. I am also not aware of any ADR mechanism set up for amateur sports currently run by the PSC. Although PSC is the lead agency when it comes to national sports development program in the country, and they are in the best position to use ADR as one of its regulatory tools to compel sports organizations receiving support from the PSC to adopt sports arbitration. So let's look at professional sports. So with professional sports, if amateur sports is for Philippine Sports Commission, ang professional sports naman hawak naman ng Games and Amusement Board. And this is by virtue of Presidential Decree number 871. So the powers of and duties of GAB are supervision and regulation of professional games in the Philippines. They issue licenses, permits for the conduct of the games. They use this power to compel parties to settle disputes. Kasi syempre, sila yung nag-i-issue ng lisensya sa mga atleta, sa mga leagues, no? Because without a permit or license from the GAB, the professional leagues cannot operate. Okay, so they have supervision over all officials, employees, and persons connected with professional games. So what is GAB's territory when it comes to resolving questions, controversies, or disputes? It has the power to consider, investigate, decide, and settle all questions arising out of or connected with professional games under its supervision based on the rules it may adopt. So GAB has been on top of professional sports and professional games. I'm sure with their administrative powers and quasi-judicial functions, they are considered the authority. And professional sports people and organizations respect their mandate and look up to them for resolutions to disputes before considering litigation. So a number of professional athletes, no, before they go to court, they try to visit the games and amusement board to see if there are remedies that can be exhausted with GAB before they consider filing case in court. So alam naman yung mga atleta, ayaw nila ng korte-korte, ayaw nila ng mga demanda, di ba? So this is good, no? Because at least GAB is being used as a tool in order to bridge between people who are fighting, no, or in disagreements. Okay. So may the PSC or GAB establish its own ADR system. So there are many schools of thought on this. No? Section 5 of the law creating the PSC states that the Commission shall be the sole policy-making and coordinating body of all amateur sports development programs and institutions in the Philippines. So kung babasahin niyo dito, I believe that the PSC has the power to require sports arbitration to settle disputes and conflicts, not only in the NSAs, yung National Sports Association, but all of amateur sports. So I hope the PSC acknowledges this power and authority to embed arbitration in local sports. So also in view of Section 181 of the Revised Corporation Code, which mandates referral of intra-corporate disputes to arbitration. So what we are saying, these are the two legal bases that the Philippine Sports Commission can use in order to require ADR and specifically arbitration. So can PSC or GAB establish its own ADR system? They are the ones who's going to conduct the arbitration or mediation. Pwede bang in-house ito? So in my opinion, yes, no, pwede. So nothing precludes the two government agencies from doing so because of Executive Order number 97. So EO 97 confers on the Office of the Alternative Dispute Resolution of the Department of Justice all ADR-related programs of the Executive Department. So it depends on how the OADR will decide on this. So pwede ding sabihin ng OADR, you might as well get a third-party provider such as the institutions like PDRCI. Kasi established na siya at meron na siyang available na rules, no? And they have trained arbitrators that are involved in sports one way or the other, or are experts in sports law and are also experts in arbitration. So ito yung mga characteristic na hinahanap natin, ano? Para ipagkatiwala natin yung sports disputes sa isang institution. So the parties may choose which mode they want to use to settle their dispute, arbitration or mediation. This is because of the principle of party autonomy. They may also consider med-art, no, parang hybrid, as provided for by the PDRCI rules. So flexible siya. No? Ano ba yung med-art? Med-art guarantees that the conflict will be resolved at the end of the journey, either through an agreement as a result of mediation or through an arbitration award if no agreement is reached. So, kumbaga, if you go for mediation at hindi siya naayos, wala siyang conclusion, so gusto nating idugtong yung arbitration sa mediation. Kapag if parties do not agree, then automatically it will be converted to arbitration. or it will proceed to arbitration para magkaroon ng final resolution yung case. So again, conflict or disputes cannot be avoided. That's true. And the problem begins when these conflicts are left unresolved. So there you go. I hope you were able to learn more about sports arbitration. Thank you for your time.
Bahagi na ng buhay nating mga Pilipino ang sports. Mula sa panahon ng unos, sa tamis ng tagumpay, sa kabila ng pagbabago ng buhay, ang Philippine Sports Commission ay patuloy na magiging lingkod sa sambayanan at atletang Pilipino.